bintimintia nkaya nkase nka appellate courts no and wouldn't be around enkobisa ko ye ni kwasi kwa tinkoni ko kwasi am akwaba
minya pato meje so na mpacho ho
hello kwasi
minya pato mechia meje so te
meka obe am mute ho a nka ye ni beje pa
ma meet you so check from your end
okay I think it is better now baby aboko there
oh radio do me ho ye pampa so so e
o nyanko padaro ma me so mu ye pa mo se eh adansidi no so bo akire ho e bo wachi pe chese
you settings the well no yes agbaro ni huhu na we no
seti atoso pepepe ti edin komo na ebetimi ayi to fi minim say kwasi minim that wa follow Kennedy Agyapong and Anas issue now from time you see esa babisi a friend saying you see ebe o ha yen yasum ye dentine de ekoso ewa bonten ne nkane kane yesronko na afin so ekura modem ho so so a ya mpanimfo te ho a wo mo sasa adwen a eno so nkomo no yesronko se say de ekoso social media ye kra ye kan bi o ha ese den na case krono edi no ha no eko say na a trap wa ekoye say now walk us through how some of these things you see yano said you see administer justice wa it betimi different from jurisdiction fufra na che said the nti betimi ama bibisa etimi aba
okay me ya me da say the edikan ma memma enyina ye nti ase say contrary to said yes, you are bonten say Mr. Nas echo Ghana court ma Ghana court to na semguye no they call US court to the US court ajatum make judgment amano no enya sa na tie asem no ya asem a different asem enya asem ba akopɛ na indeed there also tie say a case laws are territorially bound titu your criminal law for instance and even other laws are and to bit my mfonso or Ghana ha or America sad na nya mfonso obi so bit my mfonso America otwam ko Mexico nya mfonso so the laws are confined within the territories of the country
and even within America no kra no state be across state be krampa
yes and untina LGBTQ no mo na no America some states jitumba some states sunya de
anyintum
enti enya possible say asembisi wa Ghana ha na de akwa America kodi sesa na tie dia ene nka America so ka asembisi ke betimi dia ba ha nanso muko obi kuro so na bibi kosia and answer the act or the offense occurred in the territory or the jurisdiction of that particular country there ene home ran de be adwuma Sebio America for me no bagana no one more be ba ko twe second or ba ko so a e inform nko America se ko di o masem ho Ghana mra no ba ye dey ebuso America ni nam ha ana UK ni nam ha no the carbon ni power Ghana ha Ghana mra no aye dey wabuso nti Ghana na ebedi na asem nti wo hwe asem aye kan wo owura Kennedy Agyapong ene Penny Anas nsem ya the offense na nkasa was committed on the soils and within the jurisdiction of America, the United States of America. And on that basis, and need in Ghana ha enye. When they compare to the AC Wahana, the AC Wahana there, Honorable Kennedy Agyapong made those comments in Ghana here. And in Ghana court to send a bit my edi. And this will be cast a sebio, a seven or the Baha, and a year in the year near the America Yakudia. It is never the case. The facts were entirely different. Now, I say, no, sometimes we can spin it within social media, within the media space. Now, even though there is an element of truth, you know, I say, you be tuntum, no one who's so front to matuntum. O front to matuntum, I'm paying them who's so front to matuntum. As we offer to Timika say, oh, any be a year in if you be any year in if you be any issue on him. Sakamamus is you on him, yes, tuntum. And to the first social tuntum, say, a year na a day, a so if you be no in a day, yes. So there has been systemic misinformation. That's spinning certain aspects of what is going on. It is never the case, say, the matter was here and the court did not treat it well, and they call Abuche. There were two different issues, two different set of facts. Say the same set of facts I came to me new Abuche. And unti we are honorable Kennedy Agyapong papa be a friend that the Fred. One more interview in America. Interestingly, even Kennedy Agyapong was in his residence in America, and now make his interview on Zoom. And the gentleman also interview was also in the jurisdiction of America. I don't know also interview, and the act which constitute the offense of defamation, was also done on the soils of America. Didn't now be dino. Even though Ghana form kunya semno, na ye de America now be de ebedino. And she muka kraswa de no. Again, ade baako say, but what men ka de?
Eto nkapa.
Ade baako say o say adwen baso na say.
Anaya menyeje homa.
Oh, there be some media. Me say one thing to what ya. Ade baako say me hu ya adwen baso na say. Country bia or kwan of aso edi na asem. Yeah, kwan of aso your law no see working no. We take a cue from the common law. Common law no ye US for. Into your system no a bit different from UK for. Your system no a bit different from US for no. Yeah, over Ghana ha. There were two types of trial. If it be summary trial and other ones, no, you fair trial by indictment. Summary trial, and the assembly is straightforward. Offense and answer crime na ya commit no. And that there you who answer a was to be a. In prepare the judge back up a bit matter so. And the judge will apply both the facts of the case and the law of the case. Not the law, nor they are coming to the determination of the case. But don't hear trial by indictment there. It have no offense no so. I also be the second who will be no the in the case of murder no, a marriage to say, if you are judge about for one transfer, untimi mu attention ye man ye, nti ye frame kophobia film jury, na omumwano ema ye ni asem no. The jury will come out only looking at the facts, not the law. No more the one more verdict there, abba. Ade bako and said the verdict of the jury is not necessarily the judgment of the court. And the jury in the one more verdict be we are ansana court na they are adopted. Over instant case here they compare to her. In America, no, in civil matter, no, even though offense, no, be a Ghana hack, defamation may not be seen as an indictable offense, no. One more on defamation indictable offense, into a soparable, into a one of the jury trial. In the jury, no, one more lawyers, or no law who they are only privy to the facts. Now, Ghana usually we take a NIPA 7, America so often NIPA 8, no more betnaso. So they are only looking at the facts. Into say jury na so. Now, one will look at the facts and they come out with a certain decision and a certain pronouncement that you cannot compare to or be a judge in the Tanaso because juries don't know the law. They are not lawyers. They don't have any legal training. They only come and look at the facts and they may miss a point of law. And again, that comparison, I don't really get it. Why you compare a jury trial to a trial of summary conviction where a judge says on it? Because, hey, America could a jury 8 quarters now so. And Ghana judge it's not the basa. You can only compare a jury trial to a jury trial and a summary trial to a summary trial because jury in one moon law. Now we have same way Kennedy Agyapong the jury had come out with their verdict. One more verdict, almost honorable Kennedy Agyapong found on a culpable or guilty say ampa wadifemu Anas. No more the tabo Anas be a friend damages of an amount of $18 million to Papa Kennedy Agyapong so. Oshe court records in money are initially no Kennedy Agyapong lawyers FRL said the amount is so outrageous. Ghana so do interior akwonya day on teso court no shena jury no and a court no enteso and sana court na adopted. Na emu ho no court no ka say okay one mo ebehe but before that they will look at that application. But before that no court no say one mo may examine another aspects of proceedings na no your friend punitive damages. Unum so court damages ye say bio obi aya onfo so na okobọ ne ka ye wo two say a obi aso court no ye either in the form of a sentence and be in the form of conviction and damages conviction there na in criminal trials and no nipa na betumo ya bo obi tu ya ku obi ya rape obi and no criminal trial and no nipa na betum. But when it comes to civil trial ye mfo obi antum obi do ka ye mfanintum obi di femu ye mfanintum. And no ye friend no damages near sika ye hwehwe ka ye de ebebo. Na damages no ye wo mo hodo bebre ye wo actual damages ye compensatory damages and ye wo damages so and no see punitive damages. Na briefly no Mamma o scenario we ni na na tifo ni ahwefo ni na ntiase. Fa ne say obi kura car, ana ode car ni dream car pa na ode akobọ taxi driver. Car kese akobọ taxi driver, ana taxi na say he has caused actual cost to the car na taxi driver ni use. The be charge no for actual damages. Again, taxi na nkwadwuma bosome mienu bra ye repair taxi no. The yes of compensated driver no car wire the wabo and for his economic loss. We try compensatory damages. Now, court no say to me catch us, okra and you car tree and effect. The bet sure so many penny who saw about court so that is the punitive damages. Now, Americans say mono. The punitive damages is also determined differently from the other damages. And the court not say a court no busa some by punitive damages, and a jury is one more can punitive damages, and actual and special and compensatory damages in the able. And a court not sure my genesis to say no, that is not the instructions that was given to the jury. Now thereby say in jury trial, it is the judge that directs the jury on what to do, and he gives specific instructions. It is a jury obey the instructions of the court. It can constitute a ground for what you call mistrial. Mistrial, they say, there has been an error within the trial proceedings and answer processes. And the one that Kennedy Agyapong almost lawyer sorry, no say now judge, are they say treating it separately from the other form of damages? And then kofuya kokabomwe, and then kofuya no munim diamoyu. And on that basis, no sorry, raise a motion for mistrial. Say any jumedio mudi na jury no and your moon so I don't have for floor money so lawyer for budim the on that basis and the court no encha trial proceedings no my because almost to say so my mistake were had here and no my mistake so in the whole trial. And the court said, well, this is what the jury have said. But if this is the objection that you are raising to what the jury have said, based on mistake or maya, which is patent on the face of the record there, on that basis, you have to submit a written application. And the decided. So we are at a stage that the jury has brought their verdict. Mind you, verdict is not the same as judgment. It is only when a verdict is adopted by the court that is where it becomes a judgment of the court. And even at this stage, now there has been maybe a pseudo injunction on even the verdict of the jury. Why? Because now there has been an objection that has been raised even against the verdict of the jury because of some mistrial. So the judge says that he wants to give them 30 days for him to hear the mistrial application to determine say ampa is a grounds for mistrial or not. Indeed, there are two options.
But just there be a one fan can so one fan shim say hono there also to me a raise bond bia raise sikano 18 million and they say bia be hold on until say you be the asem na wi ansana damages no be to anasa o to ono sikano say o raise sikano e to nya zanete
and this actually say we don't have a judgment as of now.
But according to one of the lawyers now or more Anas lawyers no, what you do over there in America is that also raise bond, raise scano in bond. It says scano any ansana twaso or matwaso.
No, but you see, that can only come after a judgment you have obtained a judgment.
No, even as the Inter says, there is a pseudo injunction now. The verdict, there's a judge, any verdict, and tuma. Unko say, opa kotrobra. If you that doesn't want to use the verdict for anything, unko say opa kotrobra. Yes, I
No. So let's understand that part carefully.
Okay.
So the verdict has come. It is now left to the court to say about adopted verdict. Mind you, class verdict in the by Ken's lawyers had earlier on even raised an application saying take Sikana because it was so outrageous. In the answer now, assuming said judge no quality his application or test what, and then also would we be going about to say
okay? So in the same way now, beside the same people now, the same issue now, say. Kennedy Agyapong lawyers non tiasia and to marriage your friend say person family in writing no more no sadia na more contest no more contested verdict no. You have even sika also tuano. Much as here can sika no wasem. If the system doesn't accept it, then I would disancomono. Because
yes, so you must understand, say the verdict in many jurisdictions, particularly in Ghana, no, the judge is bound mostly by, or usually the judge is bound by the verdict of the jury. So you can predict, say, the judge is going to adopt the verdict of the jury. But in most cases, you may put in what you call mitigation measures. Mitigation measures are where you be a now you're able to 25 years. Now you catch a judge and say, oh, or your first time offender, or you say you can see that provocation assembly trained in judge and so. Even though you know, say there has been conviction in terms of the sentencing, the judge can't take your plea of the mitigation and even reduce the sentencing. So within this context, the verdict of the jury was not in dispute, and you have the right to even mitigate the verdict of the jury. But outside even mitigation measures, mind you, the verdict had not yet even been admitted by the court.
What were they contesting? Because if the thing has not been admitted, because I am a lawyer, are they admitting and everything? Waiting concern you, concern me.
Okay. What is now being contested is not even the decision of the jury. The jury erred in the processes in arriving at their decision. Now, yes, I'm for so. And when Kennedy Agyapong a lawyer so more file for mistrial. The Akoba and say, one more damages and I say fines and I say Kaya Kennedy Agyapong. You determine in two phases based on the instructions of the court. Court no my jury net as say the dikano ye be determine the actual and specific damages ade chena ye ba ya sa betena se ahwe the punitive damages
but kwasi
if I land that I'm sure
okay, all right.
I was allowed to land that. But what the jury did was that one more judge and the can say okay and they are sa betena se ye be punitive damage na jury ni se catch on say oh ye kwa other damage $18 million near they buy na judge and say no, that was not the instructions of the court. Until you didn't obey the instructions of the court. But mind you, one grounds for the application, or that can be a basis for mistrial, is when the jury does not go by the instructions of the court. And in the market in the Japan lawyer sorry fast who said there is a loophole. Go now go by the instructions of the court. I did some munchiche me na mukaka boom. But
judge say for that reason may accept a verdict nana.
So the judge because of sa mistrial application no emeki remember so no meki sa application orally. And a judge
no, but what happened was that judge the loophole no judge no ankasa so enwi say friends saying go and correct this and okaso monko correct no famra na
no so omo make oral application for mistrial
so in principle can't it be seen that taking said judge accepted or admitted verdict.
So now, or more judgment or more family in Kenya. There's no judgment. There's no judgment within the matter.
But then in our jurisdictions, and Kabi and Kawino, what we said, Okase, Hassan and jury, the verdict near binding on, and as a judge, also a jitum, and Kayahano, Yabaka say, what by apply, say, or stay, your friend is saying, execution of the judgment, and now.
That is if there is judgment. No, see, the jury in the Wakoya Jumon, at the end of the day, you call something summing up. The judge will now sum up every matter. No, I heard so jury in say Bibia or Moka or Moya. Aha, you really who say jury in Nina and son a judge and Bedia de Atum. Now, when I want no more yes, I then a judge who say jury no say instructions need or home money so. And the other who's a law and strategy in the tatiso. And the other camp on the camp.
About no, did that stop among proceedings?
Yes, so now the level of case in the 1 year is for the determination of the application of for mistrial. if that is to be determined, then practically it places an indirect injunction on even the verdict, because now the verdict is hanging. As of now, we can't even proceed with the verdict for even the adoption of the court, because now
at what point in time and omo try say omo 18 million no say nka omo ntemra for at what point in time?
Okay, so when the jury had earlier presented one more verdict, that is where Kennedy Agyapong lawyers also came in to say
before the supposed your friend is saying loophole
damages were determined. Yes.
Before muhu loophole.
Yes, before muhu loophole. Yes.
But doesn't that?
Say they know say case baby edu no lose practically. My main fan I mean within the simple language. Say baby edu lose. Then at that time no more be fined for punitive damages, which is also will be determined on its own. No more some for a mistake. Now, they are going to say, in jury trial, we a mistake about the assumption is that, you could have as well made a mistake in the whole trial. And there are a lot of legal precedents. People would then, based on that precedent, and set aside the whole trial by calling or filing an application for mistrial. Until a loophole no be who and will take advantage of it.
And today, young come social media, and they are sitting in are you creating the impression, sir? As a new year, enti san common aid in Kaswana.
One, Adebako say somebody like Anas beyond the maybe monetary interest a woman, he wants to clear his name because he is a lawyer and he's a senior lawyer and a seasoned lawyer even more than me. I don't see the reason why there is no judgment in the matter. Yes, you bring it out as you've won. I mean, you see, the word they use is that they've won an award. They never said there's a judgment too. They said a jury award. The Ben we are still called to be a jury name award. It is the court that makes a final judgment. Even
in that jurisdiction.
Yes, but you see, at the end of the day, the judgment of the court will have to be grounded and based in law. The jury doesn't deal with law. The jury only deals with the facts of the matter. And the facts of the matter, based on the facts of the matter, we see that you are guilty. And then it is then left for the judge who is sitting as the bench, to then justify that within the context and with legal backing before that becomes a judgment. And what has happened, the jury awarded him all right, which is in no dispute. But that has also been challenged because it has come to the realization it's a jury need a mistake.
My date, yeah, on writing. No.
I spoke to Kennedy's lawyers almost by hopefully they were supposed to send by Ochana, but almost latest by Friday they normally call. But the judge says within 30 days we'll be ruling on the mistrial application.
Whilst at it, then also 80 million. What happens?
As of now, there is no judgment, so there's nothing bounding them to do anything until the mistrial has been determined and the judge proceeds to make a judgment. Nothing. There is nothing to work with.
All right.
There is no order. Let me put it that way. There is no order against anyone.
Okay. So now let's go back to issue now. All can I say, say Omo, and time is not on our side, but let's try to see if we can do something.
But
let's see if we can do something in 2 minutes. Say. I had the no Anas Kosu Kennedy Agyapong no. I judge for netna so di asem no. But America then there. You selecting crofo no ma wo mo nya judge for jurors. And almost selecting omo tena asem no so. Nti omu wi ano mo de abre judge no na judge no so e de afamra tokrum na mra asili ansa na yaje atum. Is that what you're saying? That's the difference.
Yes, sir. You use common law. America, use common law. We use sometimes even hybrid system. We don't use our law. The procedure.
You are saying that it is misplaced for somebody to say, America for no ehunudi, Ghana for ehunudi.
asem no ko enyepe asem no say asem ba ko na de kwa Ghana na say de kwa America na
Nina defamation kura but be facts.
so but the facts are different when you see in criminal, for instance, in I'll send you the one more rate and as a rate no always state defamation but they will the count of the offense and count no but always state the particulars of the offense no and they bet share the facts and the details of the offense. The facts of the say ni nyina ye pa anka yentimi ni Ghana semo America because I told you that laws are territorially bound. In the same way Ghana yentimi ngodi wo ho. They are entirely different things. Even though the offenses are the same, no, the particulars of the offenses are different. And again, if you go to America, the burden of proof will be different from the burden of proof in Ghana. Well, if you are proving the burden of proofs are not the same because we use different jurisdictions. Yeah, the proof in criminal law may be beyond reasonable doubt. Civil is usually on balance of scale, preponderance of probability. In America, they may have their new offense, be at their old thing. Even if it is the same, the weight of evidence that you need may not be the same. What I say, it will be very simplistic for anybody to say, hey, Ghana, they assemble, I say no. Indeed, if that is the logical, and then you only collect soon a call, and now a call Supreme Court or say, Owulitia, the decision of the High Court to say his description of Anas was unjudicial. And then the say also took Ghanaian court to correct it. And again, mind you, even in America, granted without even admitting, say Kennedy loses the mistrial application, and even the court adopts same as a judgment, the verdict as a judgment to Ghana. Kennedy Agyapong still has recourse in law. He can go to, let's say, if the case was held in a circuit court, or a higher court, to set the judgment aside through an appeal or any, if so who's a procedure, he can go for an order of certiorari. Obeti musu viako, say high court and yaman, obeti mako a offender say a court of appeal, and even to the Supreme Court. As same way, if you rate now, I'll send you the rate. It was in 2022, 2025 the judgment. If there is a mistrial, no more kasomu kombu. Now people are now ready to litigate. We have to earn 4 or 5 years.
So if anybody says, Kennedy is supposed to cough up some 18 million USD, young can say
on judgment to run the money in read the entire say.
Because you have been commercial. I may try verdict, so except rate, no, try rate, no. Now, I
can forward to you right now.
All right, so now, yeah, now be a who quite a fast, so I bet also I didn't come on going forward. Because me the CP, and ombre. Lawyer, papa. All right, go V.